Hello and welcome to the final part of our webinar Introduction to Family Law. I'm Marisa Allman, a family law barrister at 36 Family, and I practice in financial remedies and children proceedings. In this final part of our webinar, I'm going to be talking about parental status, and in particular parental status across international borders. As you will know, if you are a family lawyer practicing internationally, there can be particular difficulties which arise where your client has parental status in one jurisdiction and that doesn't translate over to another jurisdiction, sometimes called limping parentage. One of the first situations in which this can arise relates to adoption. The UK is a signatory to the Hague Convention on the Protection of Children and Cooperation in Respect of Inter-Country Adoption 1993, which I'll refer to as the Hague Convention. You may be practicing from a jurisdiction which is a signatory to this Hague Convention as well, and you will know that under that convention, adoption orders made in other signatory states in accordance with that convention will be recognised without any procedure being necessary. And of course the same applies in England and Wales as part of the UK, which is signatory to that convention. Under the law of England and Wales, where that convention adoption is recognised, that will also lead to the child in question acquiring British citizenship. The situation is much more complicated where the adoption concerns inter-country adoption between countries that are not both signatories to the Hague Convention, or indeed where they are, but for whatever reason the adoption has not taken place in accordance with the Hague Convention procedure. The Adoption and Children Act 2002 of England and Wales also provides for what are called overseas adoptions to be recognised without any procedure being necessary quite automatically. That means an adoption entered into in a country which appears on the Adoption Recognition of Overseas Adoptions Order 2013 is recognised automatically without any different procedure. The schedule to that regulation currently includes a list of 87 countries, some of which are also Hague Convention countries, which might mean, for example, that an adoption which took place in one of those convention countries but not in compliance with the convention regulations might still be an overseas adoption and recognised under the law of England and Wales. That doesn't provide British citizenship in the same way that a Hague Convention adoption will, but it can assist with entry clearance for immigration purposes. The difficulties arise where an adoption has taken place in a country outside England and Wales, which is not a convention adoption and which doesn't appear on the list of 87 countries which fall within the recognition of overseas adoptions regulations. And the country in which you practice may be one such country. There is the potential within English law to have recognition of what is called a common law adoption in circumstances where, in the first place, the adoptive parents were domiciled in the country in question at the time of the adoption. The child was legally adopted in accordance with the requirements of the law in that country. The adoption has the same essential characteristics as an English adoption, and there are no reasons in public policy for refusing adoption. Adoption is one of those concepts which doesn't have the same meaning the world over. I know that in some countries adoption doesn't, for example, entirely extinguish the birth parents' rights as it does in England and Wales. And so it's an area that you're likely to require particular advice about if your clients have entered into an adoption in the country in which they live or in which you practice, as to whether it's an adoption that might be capable of recognition under the law of England and Wales. If there's an issue concerning a child's adoptive status, or if a common law recognition of adoption is required, then the court can make declarations as to adoptive status. In some circumstances, the court can recognise the adoption that's carried out in another country without making a declaration. But if the child makes an application for a declaration as to adoptive status, and if they are domiciled in England and Wales or have been habitually resident in England and Wales throughout the previous 12 months, the court may be able to make such a declaration, and that may assist with immigration entry to the UK as well. Where it's not possible to recognise an overseas adoption, then it may be necessary to apply for a fresh adoption order in England and Wales. For those purposes, applicants for an adoption order must be domiciled in England and Wales or must have been habitually resident here for not less than a year prior to the application. It also requires the child to have had their home with the prospective adopters for at least 6 months prior to the adoption. There are particular immigration considerations in this scenario, and it requires strict compliance with the adoption with a foreign element regulations. It's important to be aware that there are particular restrictions on bringing a child into the UK for the purposes of adoption, and a lack of compliance with the regulations might result in a criminal offence being committed. So it's particularly important to take advice in that sort of scenario. The other area in which there can arise a limping parentage situation, or parentage which is recognised in one jurisdiction and not another, is surrogacy. Surrogacy is legal in the UK, but there's presently no framework for a pre-birth arrangement or order to be put in place for legal parent to rest with the intended parents at birth. Nor is there currently a framework in place for orders or declarations as to legal parentage granted in other countries to be recognised in the UK. So you may have clients who entered into a surrogacy arrangement in their home country and who are legal parents pursuant to an order in that country, but if they come to live in England and Wales, that order won't be recognised as the law currently stands. There are particular acts which are illegal under the Surrogacy Arrangements Act, such as initiating negotiations with a view to making of a surrogacy arrangement or taking part in those negotiations, or offering or agreeing to negotiate the making of a surrogacy arrangement on a commercial basis. It's not illegal for non-profit organisations to do that, and so most of the agencies that assist with surrogacy in England and Wales are not-for-profit organisations. The position on the birth of the child, wherever the child was conceived and wherever the child was born, is that in England and Wales, at birth, the gestational mother will be the child's legal parent, and she will hold parental responsibility for the child. That's irrespective of how the child was conceived, where they were conceived, or whose gametes were used. If the child was born in the UK following a foreign surrogacy arrangement, the surrogate will also be named on the birth certificate as the child's mother. If the surrogate was married or the civil partner of a man or another woman at the time of conception, then that spouse or civil partner will be the child's other legal parent at birth, unless it can be shown that they didn't consent to the insemination. And that's the case even if the spouse or civil partner is not based in the UK, or if the child was not born in the UK. So you might well have a situation where the surrogacy arrangement was entered into in the country in which you practice or which your clients live, and your client may be the surrogate mother, and she and her spouse, if she has one, will be the legal parents of the child in English law, even if they're not the legal parents under the law of the country where they live or where you practice. If there are disagreements about who should care for the child after the child is born, then the courts of England and Wales can decide that. Surrogacy arrangements are not enforceable in the UK, and the surrogate is under no obligation to hand the child over to the intended parents. That may be different again to the country in which you live and practice and the country in which the surrogate lives and practices. In order for the child's intended parents to become the child's legal parents under the law of England and Wales, an application would need to be made for what is called a parental order under the Human Fertilisation and Embryology Act. This has the effect of granting parental status to the holders of the parental order as though the child was born to them. It also removes the parental status and parental responsibility of the surrogate, and it will also affect the child's citizenship and nationality in England and Wales. If the intended parents are going to be living in England and Wales, then it's important to obtain such an order in order to secure their parental status, but also in order to extinguish the parental status of the surrogate and any spouse that she may have. An application can be made for a parental order if one of the applicants is domiciled in England and Wales. Again, this is an area in which you may require advice about domicile, and if at least the gametes of at least one intended parent have been used in the conception of the child, if the applicants are, both of them are over the age 18, and if they are married or civilly partnered or in an enduring family relationship. A parental order cannot be made without the surrogate's consent. Consent is a cornerstone of parental order law in relation to children born through surrogacy. Consent may have been given in the country where the surrogacy arrangement took place, but if it was not given in the correct form, or if it was given prior to 6 weeks after the child's birth, then it may not be accepted by the courts of England and Wales. So I hope that this brief introduction to the family law of England and Wales has been useful to you. As I mentioned, this is part 6 of the series and the final part. If you found this interesting, then I hope that you will go back and look at the other parts and find out more about how we at 36 Family can assist you in any cases in which there are international family law issues which may touch upon the law of England and Wales, and provide you with advice or legal services as required.